They just want to do a vote on, see where everybody was at, because I think we've heard enough on the bill, but he's not here, so we're gonna move on to a hearing only for Chairman Pruitt. And just to let you know, this issue has been discussed here at the Capitol for a while. There was a Senate study committee led by Senator Josh McCoon in 15, and there was not any action then. And it gets pretty complicated. So with that, Chairman Pruitt, is there a table? No, you gotta stand. Okay. Well,
To be professional, I will.
all right. So I've been asked to come down to the homeschool group. So, and thank y'all for allowing them to swap rooms with us. So I'll be back.
Thank you, Mr. Chairman. House Bill 495, which is LC 363883. Make sure everybody's got a copy. This legislation has been drafted, and again, like the chairman spoke on, it has been discussed many, many times, and I haven't been privy to all the discussions been held in the past. There was some held in the House, and also I understand in the Senate quite extensively last year. And I made a commitment that, again, because I've read the bill several times, and it's kind of strange sounding from somebody that's authoring a bill, but I have several issues with it myself. And I should say, rather than issues, I should say I have a lot of questions. And other people expressed to me questions, and other people have expressed support. And I think that the best thing to do, and that's what the chairman and I discussed, and he's the second signer on the bill, is to give an opportunity for those who are wishing and would like to come and present the facts and how they feel and why this particular piece of legislation is necessary and why they feel it's necessary. So, and basically what the bill does is an attempt to try to explain a employer versus a contractor, and the definition being currently not codified in Georgia law, that we're basically using, if I understand it right, court cases and then the federal law to make that determination. And I don't know really exactly what the downside is and the upside is as to clearing up this definition, other than there are some issues out there that need to that are causing this to keep coming back before us in this committee. So at this time, I don't know if anybody signed up to speak or not. Have there? Oh, is this the list right here? We'll give that to the chairman, and I'll sit down. Thank you.
All right, we got a question, I guess, from Representative McLean.
No, I'm sorry, Mr. Chairman. No, I don't. I just wanted to make sure that everyone that signed up that wanted to speak on the bill had the opportunity to sign up, to know that there's a sign-up sheet if you wanted to speak on the bill, Mr. Chairman.
All right, thank you. All right, we got Ben Spieth. Am I saying that right? Spieth? Introduce yourself, tell us who you represent, who you're with, and all that good stuff.
Good afternoon. My name is Ben Spate. I represent the Teamsters Union. We are 10,000 truck drivers and film industry workers. We work at UPS and many other employers here in Georgia. This issue of employee misclassification has been very close to our members' hearts and, well, throughout the industry. It's close to our largest employer, UPS. Of all the states that have addressed this issue nationwide, most of the testimony has come from construction workers, and it's also come from truck drivers. In 2010, there was an exemption put in Georgia Code for truck drivers to make it easier to misclassify truck drivers than any other type of worker. And you will be able to find that in Code Section 34-8-35, Section N17. The current bill, HB 495, although we support the bill, it does make some progress to current Georgia code in addressing this crisis. It will leave in, as it's currently structured, this exemption for truck drivers. So we're asking that this code section that makes it triple easier for an employer to call a truck driver an independent contractor. We're asking for that to be struck from the Georgia Code. If not, we're going to lock in perhaps the most egregious violations of these practices. And just to be clear, this is when an employer deliberately knows full well that they control the behavior of an employee, but they're deliberately calling them an independent contractor in order to avoid several things. One, paying workers' compensation. Two, paying unemployment insurance. Three, paying Social Security taxes on the employee. There are many different reasons why, and as a result of this, you'll go down to the Port of Savannah, you'll see the condition of the trucks down there. That's where diesel trucks go to die, because the maintenance of those trucks is shifted onto the driver. And those drivers, after taxes, after they pay their Social Security and the Social Security of their employers, they're often drawing $20,000 to $30,000 a year, living in the cabs of their trucks. We testified at the Senate Study Committee hearing in Savannah. We had truck drivers come up here year after year to testify, and we're asking you that as you look at this issue, understand the scope. It affects the construction industry. It affects the transportation industry disproportionately. Thank you. Okay.
Turn my mic on. Representative Kennard, 15.
Yes, thank you for your presentation. Thank you, Chairman. I understand that the focus here is to address issues found in construction and trucking. Has there been any thought about how this new definition of independent contractor would affect other industries and have an unintended impact?
You know, this practice has become widespread. We've heard testimony from people in an individual who was a member of ours. Her father is a UPS driver, and she was classified as an independent contractor working at a tanning salon. So the model has really grown and grown to the point where if it's not addressed, it will become the new form of employment. There has been testimony. There are carve-outs as exists for real estate agents, insurance agents, and others that are considered professionals and independent in their own professions. But these are the ones that we're most concerned with are blue-collar type of workers that are traditionally employed by large companies. And in the Port of Savannah, there may be small little mom and pop trucking companies, but what they're doing is they're putting good employers like UPS at a disadvantage. Our UPS members, you know, they work for decades for the same employer. They know the communities. As what you get as an independent contractor, you might see people delivering packages in their own personal vehicle. You might see standards for public safety erode because there's no oversight of them as an employee. Meanwhile, our state's coffers for workers' compensation and unemployment are depleted because these trucking companies and construction companies and others are not paying their fair share. So the good ones who are trying to abide by the law are put at a competitive disadvantage as a result.
One more follow-up question. Has there been any feedback or consensus from the business community, from the employment side of this, addressing this law?
Actually, I've seen in other states where the chambers have come out and said in defense of those that are abiding by the law, that tend to participate most in the business community, and those that are using this practice to skirt the law. Obviously, there's a lot of debate around this issue. I mean, it's probably one of the most hotly contested issues around the country. But whether it's Republican or Democrat attorneys generals or legislatures, they have pursued this, including the state of Texas and others that have really looked at this as a growing problem in our economy.
Okay. May you take one more question?
Yes, sir.
Okay. How does this language differentiate between any kind of federal definition of independent contractor?
And that's what's so complicated about this particular issue, is that there's so many overlapping jurisdictions. For instance, we had a chauffeur driver here in Atlanta that was misclassified. We went before an administrative law judge here in the state of Georgia with the Department of Labor. He had been ruled as by the IRS as an employee, but under state Department of Labor regulations, because his employer wasn't paying unemployment taxes, there was nothing to pay him when he was laid off. So we actually had a positive ruling from the administrative law judge that ordered the Department of Labor to pay him his unemployment insurance. But I would have to litigate that case by case, and depending on what federal state agency makes that initial ruling, that's where we would have to go.
Okay.
So this would streamline it a lot more.
Thank you.
Number one, Representative Pruitt has some questions for you.
Thank you. Can you describe the definition of a contractor? Where it falls?
Yes, sir. And it is there is varying definitions. Usually, there's several different tests. The IRS has a list of tests, and that's usually the gold standard that people refer to. The Sky King case listed some of those tests, as you mentioned in your comments about the previous case law on it here in the state of Georgia. It boils down to, does the person have free and independent control to decide what they do, when they do it, and for how much they do it? If a person can't charge their own rates, if they can't choose what tools to bring, when to go, and how to report, then they're generally considered an employee. So, for instance, with these truck drivers, they're told what load to haul, how much it will be for. They cannot haul for any other trucking company. They're told the conditions of their labor. They're having to sign agreements. And part of the problem with the exclusion of truck drivers is if they sign an agreement saying they're independent contractors, according to current Georgia law, that's in that code section I referenced earlier, if they sign an agreement, no matter any of the conditions that apply to them, no matter if the IRS itself proves that they're an employee, because they sign an agreement saying they're an independent contractor, they can be misclassified in Georgia. So the concept is, if you're handing out business cards saying, hire me as your truck driver, probably you are an independent contractor. But if you're told what they call trip lease, that you can't trip lease for another company, you can't go out for hire for another company, you will be terminated. That is the norm for truck drivers in particular.
One more question, please. Two more questions,
Yes, sir.
actually. It says in this bill that they can't be told where to go.
Yes, sir.
They can't even be requested to meet a deadline. So is that part of the definition of a contractor?
Yes, sir. I think that when an independent, you would think of an independent contractor, for instance, like a plumber. They would come in, they would bring their own tools. They'll decide when they're available, and they'll decide how to fix it. They're free to cancel your order or go work for somebody else at any time. That would probably be more of a traditional profession that would be an independent contractor. These drivers are often told, you need to go from A to B, and you need to get it there by this time, and if you don't, there's consequences. That's an employee kind of a relationship. And so the definition that you're reading, even if HB 495 passes, if it doesn't remove the exclusion for truck drivers, it will lock in these practices, in particular for what we call common carriers. That's what it's referred to, again, in 34.835 in 17.
I can tell that your primary concern is the truck drivers.
Yes,
that
sir.
you represent, but I'm thinking that as a whole. The other question is, have any other states remedied this problem? And
Yes,
if so,
sir.
how?
Yes, sir. There's been states, and forgive me for not being able to quote each of them thoroughly. I would say that I recall states in the Montana the Attorney General has sued employers for what would be considered fraud and employment fraud. There have been Texas, I mentioned earlier. The National Employment Law Project compiles all the legislation that has been introduced across the country. And I know that there's a few members of this committee that have heard testimony about it before. Tennessee actually was able to pursue some of these issues too. So I think there's some
Is this
precedent
mainly
in the
referring to
South.
truckers or as a whole?
I think it as a whole. They try to address the whole scope of the issue, not just one section of the economy.
Thank you.
Thank you.
Representative McLean.
Thank you, Mr. Chairman, and also thank you, Ben, for talking. You know, I guess I have a couple of questions. So we're talking 1099 employees, or
Yes, sir.
and I guess that's one of the things. But if the Department of Labor had to say something, you know, as me, because you know I've thought about the misclassification for a few years. You're talking about wage theft. I mean, but you're talking about our Department of. I know that we're not going to have anybody from the Department of Labor speak on this, but are you saying there are a lot of money that the state of Georgia is not receiving because of what these employers are doing?
The Senate Study Committee didn't, I don't believe, put a number on the lost revenues from the state of Georgia as a result of not pursuing this fraudulent practices. The state of Georgia representative from the Department of Labor testified at one of the Senate study committees, and in fact said that due to the shortage of auditors and staff that the Department of Labor has, they are only able to inspect a very, very small fraction in the one digit percentage of employers throughout the state. So the Department of Labor actually provided testimony that the scope of the problem is far outside of their current resources.
And I know that this bill says nothing about, because there are independent contracts. Mr. Chairman, I just want to follow up, because independent contracts, this has nothing to do with insurance agents, car salesmen, or realtors, or anything like that.
No, sir. In fact, Representative McLean, there's been long established exemptions to the employment code that included professions you just listed: real estate, insurance, even the fishing industry. There's exemptions for children who are involved in a family fishing industry. The exemption for truck drivers was put in 2010. So it's not an old, long-standing practice. It was simply locked in. And the problem at the port with the, I would say, extreme conditions of the port drivers down there has only gotten worse.
Thanks.
So to follow up on a previous comment that you made, the potential lost revenue from workers' comp, unemployment insurance in particular, could be hundreds of millions of dollars.
All right. Thank you, Mr. Chairman.
Number 7, Representative Park.
Thank you, Chairman. Ben, thank you so much for being here
Thank
and
you.
advocating on behalf of the Teamsters. I likewise think this worker misclassification issue is serious, given that it does result in revenue loss to the state, but of course also given that it hurts working families. That said, reading through this bill, what it seems to do is not really address any specific group of employees or industries, but lays out or codifies case law where we're taking into, if you look at lines 37 to 40, the totality of the circumstances that they then lay out, with an opportunity for the Department of Labor to then pursue. So first question, do you have any issues with this bill other than the fact that it does not have specific, or that it does not eliminate some of those exemptions for Teamsters and for other industries?
That's correct. And let me just clarify, Representative Park, and I signed up as for in support of this bill.
Okay.
And we had members from throughout the state. We have members in every district, House district in this state, come last week, and we supported 490. We support 495. Mm-hmm. Its previous iteration was House Bill 500. Mm-hmm. We sent a letter to all the members of this committee earlier this year from our attorney explaining that we are asking that this bill simply address this super exclusion for people that are in the transportation industry. Mm-hmm. So even if this bill passes as it's currently wrote, mm-hmm. if it's not amended to deal with this exclusion, it will make it even doubly hard for truck drivers to be able to revisit this issue in the future. Mm-hmm. And so as this bill moves forward in this session and to next, we're urging those that are involved to look at amending the bill to make sure that it does cover the people and doesn't leave people behind. And it would certainly leave truck drivers behind mm-hmm. if it doesn't address this exclusion.
Mm-hmm. Based on the bill as it is, again, are there any concerns with any of the factors that ought to be considered, or just any other amendments to kind of the teeth in this bill in terms of how the Department of Labor would go after any potential violations?
No, we certainly think it's a very positive first step in the language that's new and that's already crafted there. So we think that giving the oversight, empowering the Department of Labor to pursue and open their department to receive complaints and information about these cases, I think is vital.
And just as one final point of clarification, which is a little bit off subject, based on the new employment labor project, it seems Ohio, their potential unpaid state income taxes that result from worker misclassification cost anywhere between $21 to $248 million. Potential losses for workers' comp, we're talking $60 to $510 million. So
I would absolutely assert that there are parallels here in our state, and particularly being such a large state for many different industries, it might even be more severe here. But again, this isn't necessarily a partisan question, because so many employers who are doing the right thing, our hometown company, UPS, has opposed these practices. In fact, at a recent tour of the Intergrad training facility in Duluth, CEO David Abney says our competition are independent contractors, and it's harder and harder for us to compete. We provide a superior service because we know our communities, we know our customers. But these independent contractors have not only no employment security, they have no training. All the cost of their employment is put on them. So you're really hurting the public standard as well.
Thank you.
Thank you.
Number 10, Representative Jones.
Thank you, Representative Kirby. First of all, thank you, Representative Park. Several of the questions that I had, you asked, so thank you. One last question I have for you is really around data. Would you be able to provide the committee data in terms of the intensity of the issue? I'm not suggesting that what you're portraying is not accurate, but rather I'd rather see the data behind. Are we talking 100 basis points? Are we talking 50%? And any data that you can provide to the committee, we sure would appreciate it.
No, I think it's vital, and I would certainly echo the need for empirical information to dealing with something as large in scope as this. I would say, though, that we've had difficulty getting scholars and academics and to have the resources to pursue that in this state. So what we have been able to do is gather direct anecdotal testimony that we provided to the Senate Study Committee that was held, and we're happy to revisit that. The National Employment Law Project has been able to generate some of this data, and I will gather what they have for Georgia and send that to this committee. But as Representative Park referenced, it's logical to extrapolate somewhat from other state conditions, since there has been so many studies done throughout the country, and many of those studies involve current information. But it is a lacking hole that we have with this issue, is that we need more data. The Senate Study Committee did a lot of work. Unfortunately, there wasn't a comprehensive review of the full scope of the issue in their final report.
All right, we've got a couple more questions. I want to jump in here on one.
Yes, sir.
Line 27, it says has the discretion to set his or her own work schedule. And based off something you said before about drivers and hitting delivery times, if I'm understanding what you're saying, if ABC Company is needing a driver to deliver on a specific date, and there's normally about a 2-hour window for delivery, and they literally, in your words, couldn't contract with an independent contractor, that would be an employee, because they've got to be there on Tuesday at 5 o'clock.
I think and I understand the point. I think that there are certainly owner-operators that work within that window that are true independent contractors, owner-operators. We see examples where it's regimented 5, 6, 7 days a week, start times, breaks, and it's constant directives of every load. So an independent contractor that works through a broker, an owner-operator, does have windows that they got to meet, but then they also have the ability to decline that work without any penalty. They have the ability to give that work to somebody else that works with them, as long as the work is completed. So there's just different forms of control, and we're certainly not trying to encompass people that have the kind of discretion that traditional owner-operators would have. But there are thousands more and typically that would be an over-the-road type of operation. The ones that we're most familiar with do local deliveries, and so they're driving the same truck that's been provided to them or leased to them by the company, and there's a lot more forms of control.
Should this bill then get into some very specific language between local and over the road?
I don't know.
And defining how far is local.
Well, I defer to the legislature how they would like to further define and clarify. I would say, though, that the exemption for truck drivers is so broad that it encompasses people that we would think and assert are misclassified, while trying to protect, I assume, people that are properly classified as independent contractors. It was confusing to us while that exemption was put in there to begin with, other than trying to capture perhaps more people than should be in there. That's certainly been the effect. So if you look at that section N17, there are further stipulations for truck drivers in particular.
All right, thank you.
Thank you.
Number 16 is No, it's not Kennard. So.
Thank you, Representative. Thank you, Chairman Kirby. I was, hey Ben, I was interested in actually kind of a follow-up with Representative Jones's request for that data, and the likeliness that that might not be so readily provided. Is there, being that at least because the bill, at least within Section 1, details, hopes to shape how we would categorize what an employee falling under this might fit, even though it may not be tailored directly to truck drivers. Do you find that possibility that maybe other similarly situated employees, who are within the ranks of the Teamsters might be able to provide some additional information for that data to be able to show that these violations exist?
Yes, absolutely. We're are eager to have some comprehensive study done by the state or an independent academic authority that can actually fully capture it. The problem is that these entities are breaking the law. Their goal is to try to obscure the truth. They're not going to necessarily divulge their practices in a transparent way. So it's really, in many ways, a law enforcement question. And some of the data that I've seen from other states, again, has been taking a sample and trying to extrapolate what the further scope would be. Again, we have provided firsthand, and we'll, again, provide firsthand testimony from folks right here in Atlanta and folks throughout the state. Another concern is that, just so you know, if independent contractors seek redress from their employers, they can be sued under federal antitrust laws. They cannot collaborate to advocate for their collective well-being. So if they said, hey, we want to be paid more, or we want to have a meeting with you, they can be terminated, and there's no recourse under the law. So it's very difficult to get people to give testimony because they can be retaliated against. So that's another reason why we have difficulty gathering the data we need.
Thank you for and just a follow-up. Just are you aware? We want to make sure that it's we still maintain an environment that's good for businesses to invest in employees and be able to operate. Do you know if there are any circumstances where we're looking at where previously, maybe in these other states that you speak of, where the employer themselves has been held accountable, in terms of violations of this, to the extent of being sued or criminally prosecuted?
In fact, there have been. There's been cases where truck drivers, and you can believe it, these are CDL licensed drivers. You would think of them as middle-class models in any community, but in Savannah, they have actually filed wage theft claims that they were paid less than a minimum wage, $7.25, because of the expenses they have to pay out of pocket, and because of all the time they wait at the port, they're not paid for. So if you encompass all their work time, they're making less than a minimum wage. But speaking of a business-friendly environment, our gold standard for our relationship is UPS. They're right here in Atlanta, as everybody knows. They employ all of their employees. 250,000 are direct W-2 employees. They do very well for our economy. They do very well for our state. They do very well by their employees. They're put at a competitive disadvantage if they're running up against people, and UPS has tentacles throughout the logistics industry, against these firms that are skirting the law. So it's pro-business for those that are doing the right thing, and I think that's very important to note.
Thank you.
Thank you. You're out of questions.
Okay.
So
Well, thank you for the opportunity to speak before you today.
next
on
we've
this
got
important
Brett.
issue.
Now, Brett's got to learn to spell his last name where it can actually be read sometimes. So that could be about 3 different letters here to start with, but I know who you are, Brett. So introduce yourself, who you represent, and we won't pick on you too much.
Thank you, Chairman Kirby. H-U-L-M-E-Q. I'm Brad Hume. I represent the Southeastern Carpenters Regional Council. And I appreciate Chairman Pruitt bringing this for discussion. It's critical. It's long overdue. And this committee has, in the past, bipartisan support, tried to address this issue, acknowledging it's a problem. HB 495 comes before you as a good business bill to address market equity. That's the gist of it. So as to provide clarification on worker status, what's an employee, what's an independent contractor? According to the Department of Labor, you're either an employee as a worker or an independent contractor. There's no middle road, there's no part-time, there's no hybrid. It's either or. You can choose the industry, and hopefully a lot of these comments will address some of the questions earlier. You can choose the industry: entertainment, home health, hospitality, construction. You heard prior, trucking. Choose the industry. For this conversation, I'm going to center it around construction. North Carolina did a study, 2014, empirical study, and documented a 20% competitive disadvantage to businesses playing by the rules, classifying their workforce appropriately. 20% competitive disadvantage, just by playing by the rules. In addition, the tax loss that comes from this misclassification, which I'll address in a minute. Georgia currently has nothing codified. As was mentioned, any business here or looking to come here must seek court decisions so they can properly make a decision on how they're going to classify their workforce. An undue burden on business. I've been asked in the past by members of the committee, in the absence of everything codified, wouldn't the Fed definition apply? And here's the reality. The federal employee definitions apply to wages, safety, discrimination, federal employment, and income tax laws. Stops there. The state responsibility is for state wages, unemployment, discrimination, workman's compensation, and state income tax. So in the absence of anything codified, the Fed has left it up to y'all. So y'all have the right and, quite honestly, the obligation. It would be similar to the education, where the Fed has some general guidelines in education, but leaves it up to each state to get specific. Same thing with workman's compensation, and if you want to go so far, right to work. They left it up to the state, which is your obligation. This bill currently does not change existing law. It helps clarify the other demographics of working Georgians that are currently not exempt. Now, although I agree with the prior speaker that does need to be addressed, that would encompass changing existing law. And to be fair, to change existing law, you should consider how the other 17 demographics are affected. You're not being asked to change law here. You're being asked to protect and provide clarification for all the other demographics not currently excluded. Section 1, lines 19 through 31, codify the 2012 Georgia Court of Appeals Sky King decision, or tests of employment. Okay? In Section 2, lines 48 through 68, this addresses penalties modeled after current Texas legislation with input from our current DOL Commissioner Butler on some of this language. Commissioner Butler has testified to this committee as recently as last year that clarification is needed on this issue. And further, as you heard prior, the funding mechanism for compliance is absent. This section allows a revenue stream to begin to provide a funding mechanism for compliance. In line 70 through 93, it addresses whistleblower protection for workers reporting suspected wrongs. The DOL, Georgia DOL, does have a link on their website where you can report anonymously if you suspect wrong. This guarantees protection. In summary, House Bill 495 is a good business bill to address market equity. Why? It helps current Georgia business and businesses, again, looking to relocate here, an easier way for clarification. It also rewards all businesses playing by the rules. It's good for the workforce because it provides clarification up front on their proper status. So if, or God forbid when, they get injured on the job, they're not surprised that they don't have workman's compensation. Or worse, at the end of the year, they don't receive a tax invoice for 15%, which would include the employer's responsibility for their portion of the federal deductions. It's good for the state because the 2016 Georgia Department of Labor audit shows on misclassification, pre-audit payroll and post-audit payroll, a $10 million difference. That comes from only 2% of the businesses in Georgia that they audited. I submit we could be looking at a potential public education budget that's out there, should these revenues be received. So the state can have access to a current revenue stream without raising taxes. What a concept. Let's not kick this can down the road much further. We've had this discussion for several years. Everybody agrees it's a problem. The chamber, the ABC contractors. This seems to be the first full measure of resolution that's been bipartisan supported and a little bit wider in its cover. If you would like any further information on southern states that have addressed this, we'd be glad to provide that documentation, including lost tax revenues, and I'll restrict those to southern states. Thank you for your time, Mr. Chair.
All right, well, thank you. And you've got no questions, so we'll go on to James. Do you have anything new to add, James, or more the same? It's up to you.
Not really. I just got
All right, come on up, introduce yourself. I'll get back to you after James do it.
I am James Williams. I'm the political coordinator for the IBEW for the state of Georgia and the lobbyist for IBEW Local 613. Also, one of my jobs when we're not in session is to go out and find electricians throughout our jurisdiction that I can place with the 100 electrical contractors that affiliate with my union. And I can tell you firsthand that I can't even really count the amount of jobs that we've gone to and done investigations on to find the electricians and recruit them for our contractors, that they're being 1099. Now, these are workers that are told when they're supposed to start every morning. They're being directed by foremen and superintendents on what they're supposed to do and how they're supposed to do their job. They're provided the material to do their job, and all of those are in violations of the Sky King decision. In the last 2 weeks, or the last week, I've actually had 4 people come to my office looking for work. And when I pull their employment history, or when I ask them for their employment history, it's a 1099 from a temporary agency. And I ask them those questions: did they tell you what you're going to get paid? And they said yes. I go, did they tell you when you were supposed to start and stop? They said yes. I go, did they provide you the materials and the information to do your job? And they said yes to all of those questions. So this is, and on a personal note, and I can back up Ben's claim as well. My wife used to work at a spa. She was a receptionist, and she was actually considered or labeled the spa manager, and she was 1099 at that job. So clearly a definition of an employee, but is being abused by the system. And that's pretty much all I have to add on that.
All right, well, thank you. All right, I did skip, you were a little slow last time, Representative McLean. Did you have a quick question?
Yeah, I mean, it was,
Comment?
just a quick, and I think either Ben or either Brett or either James can answer either or, because I just don't want us to think that, I know we've had this problem for a while, misclassification, and I just want to know, I know the DOL has taken some steps to crack down on misclassification with employers by employees, and I just wanted us to say that if you would just share what you think those steps were, or are they going in the right direction, or because I know that they put some things on the web page, and I'm just trying to figure out exactly, was that in the right direction, or we know we need more and as far as a bill, but what can we do until we get something? To one of you three. I mean, I know everybody on me. Yeah.
You do need to go to the mic.
And I mean, if anybody else want to follow too, I mean, if you think, because again, the Department of Labor was here earlier, but they did leave us. So, but I do want to make sure that we can help them as well.
We have seen the Department of Labor take an increased interest once the Senate Study Committee was held, and as was mentioned, the website function to report it, we think is a very positive step. But if it doesn't have the resources to pursue these allegations, and further, if it doesn't have the ability to go out and seek them even without an immediate report, just due to for compliance purposes, with no enforcement, it becomes moot. And if it doesn't have the full scope of the problem, then they're only looking at a small section of the instances where this actually occurs. So it's a positive step. We believe that 495 moves it even further, and that's my testimony addressing the truck driver carve out. Yeah.
All right. Well, thank you. And this, this is a hearing only. I know we've talked about this in the past as well. It is an important subject, and I know we've got a lot of work to do between now and next January, and a lot of the stakeholders, I'm sure, will let us know what they think. So we appreciate everybody's time and comments. And Representative Pruitt, it's your bill. You got the closing comments on this hearing.
Thank you, Mr. Chairman. I just wanted to say that thank you for all of you that came and spoke today, and we do need whatever information that you might have available. And I'm very curious as to what other states have done. I'm also curious about the fact that you mentioned that the Labor Department can already do some of this if they had the funds. And other than the trucking industry, is there a possibility that that's the only thing that needs to be addressed? Since they're already out there doing it, just don't have the funds to police it based on, I understand what you said. But this committee is very interested in this subject, and obviously we represent the people of the state of Georgia, and that's what we want to do, and we want to do it properly. And I thank the committee for coming and listening today, and it's up to the chairman where in the future, if he wants to have another hearing on it. I think we're a long way from having all the information we need. I'd appreciate anything that you could bring to me and that we could get back to the committee.
Thank you, Chairman Pruitt. And again, keep supplying information to us. Okay, next, Kirby on, and is there a substitute? Okay, LC 363924 substitute. If you could just explain the
Changes. Yes,
the
sir.
change.
Thank you, Mr. Chairman. I bring you HB 110. We've talked about this bill quite a bit, and partly I apologize. We got in the weeds on some different parts of things that were already in current law, but wanted to make sure the committee understood. What we've done is we tried to listen to everybody and take your input. You'll see the first change on line 21. We just switched the order of the third and fourth way of paying people. Representative Pruitt brought up that wording about consent. And talking to Legislative Council, they said it was fine like it was, but you know, if it wasn't on Schoolhouse Rock and Conjunction Junction, I don't get it. This makes sense to me. So that's what that change was just changing the order. And then Representative Kennard brought up a great point when he said he heard from small businesses that they didn't want to be burdened. And I've talked to the Georgia Manufacturing Alliance, Jason Moss, and I know he pulled some of his business as well. And they said basically the same thing. Don't burden us, just let us take care of our people. So we took out all the options and say, look, this is, or making them choose different options. And this just simply says, we're going to take care of our people and pay them with one of these 4 ways. And that's all the bill does. And don't need a whole, I think we've talked about it quite a bit, so.
Representative Park.
Thank you, Chairman. Thank you, Representative Kirby. So how long has, I understand the intent. I think one of my concerns I still have with this is, whether or not this is a solution for a problem, right? So, for example, to begin, I should say, this code section 3472, how long have we had that code section where the discretion exists with the employee?
Quite honestly, this is some, in my opinion, overreach of some judges that have caused that. I think if you read the actual code section, it never was intended to be that way, but some judges changed it, and when that happens, we come back in here and we have to correct it. It is a problem when you have companies that no longer write checks, when you have small employers that don't do direct deposit, and somebody's insisting on making them change their business model to do something different. It creates problem, it creates cost, and it's just let employers take care of their employees. That's all this is really about.
If I can follow up. So have there been any cases where employees have filed suit and been successful in requiring an employer to pay them a certain way,
Yes,
given
that's
the
why we're
discretion
here.
they have? So could you provide some of those case citations?
I don't have the case law off the top of my head, no, sir.
Okay. Because again, I think my primary concern with this is, with any changes to the law that we make, there are unintended consequences. So whether or not the benefits, potential benefits that this could result in, whether or not that would be outweighed by any unintended consequences, especially if, this issue is not something that has disrupted the employer-employee relationship.
Chairman Pruitt.
I'm sorry, I'm still a bit confused. I'm going back, looking at paragraph on line 27 through 32. No, I'm sorry. Yeah, section C, I'm sorry, 33.
Mm-hmm.
If a person, firm, or corporation that elects pursuant to subsection B of this code section to make wage and salary payments by using credit card or payroll card account shall provide the employee with. So going back to section B, who's got the discretion to make that decision? Because in that section it says if they provide them an explanation.
Okay, the part you're talking to refers to, and I certainly agree with it. If they're going to use those payroll cards, they need to know exactly
I
what
agree.
they do, how they work, if there's any cost. And C goes with the written explanation underneath it, and that's what I pulled out last time. I didn't bring that card back with me. Section B is just the 4 routes, and if they use the payroll card under B, then they make sure the employees understand.
Okay, so it's
In our case, it doesn't cost them anything.
Okay. So under line 16, it says upon the discretion of the person, firm, or corporation. So that person in that particular section, is that talking about the employer?
Yes, that goes back every person, firm, or corporation, and it goes up the line above it on line 12. The same wording to describe the employer. A person can be an employer on 12.
Okay. While y'all were I did a little investigation myself, and in my discussions, had an intern in my office actually got paid by one of these cards because I was a little confused myself. These are not cards that they get at Walmart or through a bank or anywhere. I don't know where they get them, but there is no cost because the employees already have the card in their possession. And then they give this particular employee worked at the Atlanta airport with one of the food courts. And she did not have a checking account, so they just gave her a card, and she could go to a bank or an ATM and get her money out. There was not a cost.
Right. And that's what I think that was 3 or 4 years ago. When we put the pay card wording in here, Roy, do you remember? It hadn't been that long ago, but when they, that was something
It's
new.
been since I've been here.
I think about 4 years
All
ago
right.
was when we did that, but my memory's not as good as it used to be.
Okay, Representative Park.
Thank you, Chairman. Sorry, one more question that just popped up. So on lines 16 and 17, we're saying upon the discretion of such person, firm, or corporation, we're giving that discretion to the employer. Under the same section, section B of this code section, we're also talking about scheduling of when those payments would be made. Would giving discretion to the employer also give them discretion as to when employees get paid?
Employees determine payday now already. It's what's in the law.
Right. So employees determine when they get paid. Employers
Determine their payday, yes.
Okay.
Whether it's a 1 week or 2 week, I mean,
Right.
there's no change in there, so.
Yes. Well, looking at lines 27 to 32, as that's still in section B, would that provision, right? Would that new line from 16 and 17 also apply to, the minimum time periods in which an employee would get paid?
I mean, it doesn't change the current law on when the minimum time periods. Anything in here is not changed, so I'm not sure I follow your question.
So because the change that we are making is within subsection B, that also stipulates, for example, that employees would be how they would get paid, 2 equal periods, et cetera, et cetera. When read together, right, does that discretion, would it allow, would this change, would an unintended consequence, for example, be where the employer would be able to, pay an employee once a month, once every 2 months, once every 3 months, given how it's all read together within that same code section?
No, because on line 29, a month will be divided in at least 2 equal pay periods. And that's current law, so it does not change current law at all on that part.
All right, thank you.
Yep.
Who's next? Holly? McLean.
Thank you, Mr. Chairman. Representative Kirby, I guess 16 and 7, I guess we're all going back to line 16 and 17. Could you explain to me why you added upon the discretion of such person, firm, or corporation? And I mean, instead of just leaving it like it was, that's one question.
We can break it down real simple, Representative McLean. If you believe employees can dictate to the company when they get paid and how they get paid, you don't like this. Employers decide to take care of their people and pay them. That's what this says. And it's not supposed to be a whole lot more than that. And I know, you and I are going to disagree on this one. We didn't on the other one, but we on this one. So, that's all it really is.
So I guess, follow, Mr. Chairman, just 2 things. Upon the discretion of such person, I'm just saying you added that, but this is already law. So how many have employees been telling employers? Have employees been telling employers to how they get paid before you added that line?
Yes, that's why we're here.
Oh, okay. And I think before you took the opt out on line 46 and 47. So was that the reason we took the opt out?
It's no longer would be needed.
Okay. So once I tell you how Mr. Chairman, I guess it's just one of those things. So once you tell me how you're gonna get paid, that's how you're gonna get paid, regardless if I really can't, if I need a check, so I can't opt out to say, I tried this card, but this card really don't work. Can I get a check? One time we had that in there where you could do that.
Well, and Representative Kennard originally, was the one that first brought up that the small business guys said, don't handcuff.
Y'all agree on that on business on employer side.
So when
I'm on the employee side.
Yeah,
And that's where we differ. I'm on the employee side.
Employers need, employers determine how their people get paid. It shouldn't be this much of an issue, I don't think, but it seems to be.
Thank you, Mr. Chairman.
Representative Holly.
Thank you, Mr. Chairman. And thank you, Chairman Kirby. I know it's been, for the times it's been up here, you've done a lot of edits and to try to make it right. I think, though, within one of our times we were discussing it, I think you made it seem a lot simpler instead of focusing on, like, for here, lines 27 to 31 about the different pay dates and the periods and all of that. Do you think it just might be, and I don't know, maybe this is just me being a little idealistic, might be a little simpler just saying that that they can be provided a way to get paid through the payroll card, just without making so it's not at the expense of the employee. Just like Chairman Werkheiser said of his intern, that here they got a card, there's no expense to them, they can just use it. So if that's the case and it's that simple, why are we making it harder? Why can't we just say, there's no use the card at no expense to the employee?
There could be. What we're doing is making it where if a company wants to give checks, if a company wants to pay everybody in cash, they can go do it. They don't. We're not. What we're saying is, company doesn't. They have to use one of these 4 ways to pay people. That's already in current statute. All right. Choose how you want to do it. Take care of your people.
Okay.
Chairman Pruitt.
Thank you, Mr. Chairman. I just want to see if I could help maybe clarify some things. There was a bill passed, I don't know if it's last year or year before last, and that's why this bill is necessary, because some judges had misinterpreted what we had put in the bill previously. And what we're doing only is me, even an employer, I've always determined how I was going to pay my employees. I've always said, okay, this is how we pay. This is when we pay. If the people don't accept that, it's okay, I understand it. The other thing I was concerned about the card, as you know, Representative Kirby, was in my district, they may be a real issue, and I didn't want employers being forced or deciding to use that, and then the employees having to suffer. I thought, well, that was a dumb idea for me to even think that. Why would I, as an employer, ever do something that would not make my employees happy and satisfied, because I wouldn't have them coming to work for me if I was doing things, and there's already a major labor shortage. But basically what you're trying to do here is go back and correct an issue that was misunderstood by the courts. And we're going back to the system that pretty much that we've always had. Here's the employer, and this is the way this is the 4 options he has to pay, and it's just one of those options that's being created so that the employer can use it if it's desirable in his area and good for his business and employers.
It's nothing new being created. It's already exists.
Well, I'm saying you're right. In the past bill, it was already passed in the past bill. That's correct. But it's a clarification on the employee not determining to the employer how they're going to, you don't go in and say, I'm going to go to work for you, but this is how you're going to pay me.
And right now
that's the way they're interpreting it now, and we're just trying to correct that problem. And what you see is current law, except the things that are underlined. That's the only thing that changes. So the definition of when you get paid and all that stuff is no different than it's ever been.
Right.
In
But
three
I don't know if
hearings,
that helped clarify.
in 3 hearings, I think that's the best explanation I've heard yet. Thank you.
Can I call the motion?
Well, we've already had 3 hearings. I really don't want to belabor this, and we're past our time. Let's make it really quick. Kennard, I'm sorry.
Okay. Thank you, Mr. Chairman. Yes, Kennard, thank you. I wanted to qualify my remarks from the last meeting about small business, and I know there's different definitions of that. I'm thinking more of the mom and pop shops. 75% of Georgia's small business is 10 employees or less, and that's the kind of thing I was talking about and wanting to bring it just that scope of business that may be burdensome for someone who's just got a few employees and having multiple forms of payment. But I think that there's something to be said if there's larger companies with larger payrolls offering multiple forms of options may be warranted. But I wanted to clarify my remarks to that classification of small business.
And I appreciate that. And as a discussion we had, if we get into something like that, then we're having to define when small, when's medium size, what's large. And The big guys, they can choose all of them, so I think this does give them the options and room, so.
Okay, Chairman Fleming,
Move to pass.
is there a second? All in favor, say aye.
Aye.
All opposed? No. Okay, so we need a hand count. All in favor, say aye, or raise your hand. I'm not voting right now. 1, 2, 3, 4, 5. Okay, all those opposed, raise your hand. 1, 2, 3, 4, 5. Okay. As chairman, I'm gonna break the tie and I'm gonna vote in favor of and let the rules decide if they think this is worthy of moving further.
Thank you, Mr. Chairman.